Second part is about the case study involving services. The third part is about the risks related to the customs and trade compliance. The fourth part is about practical action suggestions. Now, let's first have a look at the first case study. We have three entities here in this first case: importer A in China and manufacturer B in country X. They are both subsidiaries of parent company C in country Y. A imports goods from B and C owns the rights in trademark which are attached to the goods. In the intercompany sales contract between A and B, there is no concrete requirement for the payment of royalties. Meanwhile, in accordance with separate agreement with C, A is obliged to pay a royalty to C in order to be permitted to use the trademark on the goods. We have the diagram here, which shows the relationships between these three parties. So actually, import A has been importing the same goods for a number of years into China without declaring the payment of royalties to China customs. But just several months ago, it received a notice from its local customs office in China inquiring about its royalty arrangements. Customs alleged that a substantial amount of unpaid duties and taxes may be due, and together they will be faced with potential administrative penalties. So the importer A, after receiving the notice, felt quite nervous. Actually, they found us and asked for help from us. In our talk with importer A, we got to know that actually importer A wasn't aware of, declaring the payment of royalties to customs. They thought that they fully complied with China customs requirements in importing the same goods. So they felt quite confused when they were confronted by China customs officers. This point is quite common in the multinational companies which have few subsidiaries in China. So most of them are not aware of this requirement that they have to declare the royalty payment to customs when they import goods into China. And another point is that I want to stress in this case, actually they hired or employed a third-party logistics service company to help them go through the customs clearance process. And always this third-party service company, they put fast customs clearance as their first priority. They pay low attention to the customs requirements and regulations. They think that their clients, they are responsible for giving the right and accurate and lawful information to them, and then they just fill in the declaration form in accordance with the information provided by their clients. So in this process, you see the clients, the importer, they think that the third-party service provider will help them verify the information and help them provide the right and accurate information to customs. But the third-party service company, they think that the client will give them the right information. So there's a missing of right information here. So in this case, to sum up, the customs compliance issues can be summarized into 2 points. The first point is that pursuant to customs laws and regulations, royalties and license fees are to be added to the transaction value of imported goods if they are related to the imported goods, and secondly, they have to be paid as a condition for the sale of the goods. So once they are added to the transaction value, they become part of the customs value based on which customs duty, VAT, and excise are levied by China customs. This is the first point in respect of customs compliance issue. So usually this point is ignored by the importers and even the multinationals in their management of cross-border transaction. They are not aware of this requirement. They have to pay to declare the payment of royalties. The second point is that it's also a requirement by law that importer had, as I just mentioned, to declare at the time of entry whether it has paid any royalties or license fees relating to the imports. I just want to develop a few more points on this part. Actually, the provisions are quite clear, but at the same time, they are also quite abstract. As you can see on my slides, the provisions are as simple as they may look, but if you go into it, it's actually quite abstract and quite obscure, especially with respect to the judgment of whether royalties and the license fees are related to the imported goods and paid as a condition of the sale. On the other hand, the trading facts vary from case to case in business reality. So how to apply these abstract and even obscure provisions to the business reality is also a difficult question faced by the businesses. To go deeper into it, from customs perspective, the royalties and license fees are typically related to the following rights: patent, trademark, copyright, and the rights to distribute or resell. So in this case, it's related to trademark. According to China customs laws, the royalties and license fees, how to judge they are related to the imported goods. In the case of trademark, there are the following situations: if the imported goods bear the trademark, or can be resold directly with the trademark affixed after importation, or can the imported goods contain the right of trademark as being imported and can be resold with the trademark affixed after minor processing. So this is about whether the imported goods are related to the royalties and license fees. The trademark right is related to the imported goods. So regarding the question whether the royalties and license fees in the case of trademark are paid as a condition of sale, the law says without payment of royalties and license fees, the buyer cannot buy the imported goods, or where without payment of royalties and license fees, the transaction of the goods will not be concluded under the terms and conditions set forth in the sales contract. The payment of royalties and license fees shall be deemed as condition for the sale of the imported goods to the customs territory of the People's Republic of China. So these are the provisions I'd like to point out here in the case of trademark. In the present case, the customs officer argued that it's obvious the trademark, the royalties and the license fees paid for the trademark right is related to the goods, because it's related to the import goods, because import goods bear the trademark. So for this point, we agree with the customs. There's no doubt about this point. But the thing that on which we can't agree with the customs officer is whether it's paid as condition of sale. Customs officer argue that because the importer and exporter, they are related, and then also both are subsidiaries of a parent company. So there's sort of a controlling relationship between the importer and exporter, and between the parent company and the subsidiaries. So it can be deduced or inferred that it's paid as a condition of sale. So still, we are talking with the customs, and we try to convince them that this customs law, the provisions in the customs law can be explained and understood in another way, different from what they believed. But this there will be a lot of efforts and time to be devoted in this case. And the thing I want to say here is that if in this case the good thing is that there's no concrete requirement in the sales contract that the royalties has to be paid as a condition of the sales contract, as a condition of the sale of the imported goods. If the sales contract mentioned the royalties and license fees, the license agreement, then the customs officers will have more evidence to prove their viewpoint. That would mean less room for us to argue in favor of our client. So this case is still in the process and in the procedure. So we wish that we expect that the administrative penalty will be exempt, though we're not sure whether there's a substantial amount of duty pursued finally by the customs. But we are trying to exempt our client from the administrative penalty. So this is the case, the first case. And let's look at the second case, case study 2. The second case about the TP is a typical TP case. As you can see from on the screen, before 2015, product P was imported into and distributed in China by an unrelated Chinese distributor. So it's also a company's group, and they distribute the product around the world, and China is just one major market. So as it's our observation that as the business develops and grows in China, in Chinese market, their trading mode and business mode will also evolve. So you can see from the screen, this this company is also evolving its trading mode and business mode in China. So before 2015, it cooperated with a independent, separate Chinese distributor, and after 2015, between 2015 to and 2016, they established a subsidiary C in Shanghai, which replaced the original distributor, the Chinese distributor, and began to import and distribute product P in China. But the import price remained the same. And then from 2017, the group is adjusted TP policy, with the import price of product P declining by 50%. If you look at the subsidiary C's financial structure, you can see before TP adjustment, its cost of goods accounts for let's see. Sorry, I guess there's some mistake in the slides. Actually, the profit remains the same, 10%, and the blue box is about let me see, the blue box before operate cost of goods. Oh, sorry, it's right. I got it wrong. The cost of goods is accounts for 10%, but operating expenses account for 30%, and then we have the profit accounting for 60%. It's before TP adjustment, but after TP adjustment, the cost of goods remains the same. The percentage remains the same, but the operating expenses rise drastically to 60%, and then we get the profit accounting for 30%. So the reason is that subsidiary C signed and executed a service agreement with its parent company, and by which subsidiary C paid a substantial amount of service fees to its parent company. So this is a basic trading facts we have here. Then the customs issues come. Local customs detected the price decrease of product P, and then initiated inquiries into the trading facts. Because as we observe, the customs, we have this kind of risk analysis and warning mechanism. So as you can see from the previous slide, there's a drastic decrease of the price, which was easily detected by local customs. And local customs officer, they inquired into the trading facts and collected from the importer some documents, and one piece of the documents is the service agreement. The customs officer concluded this agreement was quite empty in substance, and the contents of the service quite vague. That means the customs officer thought that there would be no substantial service contents in the agreement and provided. So subsidiary C was unable to provide convincing explanation and evidence regarding the contents of the service. At the same time, Customs Officer collected the gross profit margin data of other distributors of the same or similar products and found that the gross profit margin of subsidiary C is much higher than other distributors. So they think that the price declared by the importer of the imported goods is low. So they decided to revalue the import product P and pursue the duty unpaid. So in this case, the importer, the enterprise, were also confused when they were faced with customs inquiry and audits, which is, however, is quite understandable and also quite common among multinational companies. Another thing that struck us, impressed us most is that the company, in their communication with customs officers, they stick to their tax perspective and insist on their TP policy, which they thought that was accepted by the tax authority, should not be challenged by other government agencies. So it's sort of in quite big conflict with the customs, and they can't communicate with each other effectively and efficiently. And besides, they provide documents as requested by the customs officers. In this process, they just submit whatever documents the customs officers requested without questioning whether these documents can be provided to customs officers. So, like in this case, the service agreement just is a piece of evidence that's not favorable for the importer. So this case is concluded with the result that the importer paid a substantial amount of duty. But in some other cases, we processed, the result could be better or completely favorable for our clients. So in this part, I would like to go deep into some points concerning the TP. I think TP is also the issue that our participants are more concerned with. So in practice, the transfer pricing policy and its implementation as a whole is quite likely to be questioned and rejected by customs authority in China, even when the transfer pricing is accepted by the tax administration. Customs and tax authorities adopt two different, even conflicting sets of rules and methodologies as regards transfer pricing issue, which is not only in China but also around the world is sort of the same problem. The tax and customs authorities, they have two different sets of rules and methodologies concerning transfer pricing issue. For customs, the grounds for rejection is that the related party transaction influences the transaction price based on customs examination in accordance with customs valuation rules. So this is the basic um, knowledge that multinational company has to have when they are faced with customs inquiries or audits. Otherwise, like in the case study 2, the enterprise would not understand why customers challenged their TP arrangement. So noticeably, transfer pricing is drawing increasing attention from China customs. So far, a number of industry-wide customs audits of TP have been initiated, targeting various industries, especially automobile, pharmaceuticals, and luxury goods. Many MNEs have been audited, and usually quite substantial amount of tariff and taxes were collected subsequently. And since 2016, the importer is required by law to declare the time of entry if the buyer and the seller are related, and if their relationship has influenced the transaction price. So this legal requirement implies that China Customs has singled out related party transaction as a major customs issue. As a result, importers shall make truthful declarations about these two items. Otherwise, consequences and punishments may follow. So that brings more compliance risks to multinationals. Besides like if the TP arrangement is challenged by customs, that means more uncertainties in their TP arrangement and more financial implications and burdens for the MNEs. So these are the few things that I would like to stress in case study 2. As we have already mentioned, we have 2 points of customs compliance issues here. One is why customs challenges the arrangement. It's based on the provisions that the transaction value of import goods shall be accepted, provided that the buyer and the seller are not related, or where they are related, that relationship did not influence the transaction value under relevant provisions. And also, the import is under, as we just stated, is under an obligation to declare the time of entry, whether the buyer and the seller are related, and if the relationship influences the transaction value. So these are the 2 case studies. Then we move on our next part, customs and trade compliance risks. I believe that through these 2 case studies, the participants may get some feeling that China Customs administers a large scope of responsibilities. So from customs perspective, I'm not. I don't know if you, our participants, how much they know about China Customs and its responsibilities and its functions. It's how it works. But I just give you some basic things about China Customs that may help you understand why that means a lot of customs risks, compliance risks in the current cross-border transactions. So traditionally, China Customs collects customs duty, VAT, and consumption tax on imports and imports-related license fees and royalties, controls the security and legality of import and export activities, supervises customs control zones and bonded operations, imposes administrative penalty on non-compliances and IPR infringements, and even conducts criminal investigation into smuggling. So now, China, with the institutional reform of the city councils, uh, um, city councils organization. So China Customs responsibilities have further, with the reform rolling out, the China Customs responsibilities have further expanded to include all the functions of entry and exit, quality inspection, and quarantine that were used to be performed by another agency. So you see, China Customs administers an extensive range of responsibilities, which dictates there is substantial amount of customs compliance issues and risks besides tariff issues, as we have been talking about. So in their cross-border transaction and supply chain management, the multinational companies have to manage more customs compliance risks than ever. Another thing that is not shown here in the slide is that China Customs enforces a specialized legal system. This legal system features an intricate web of international agreements, laws, government regulations, decrees, and it is very different from the fields that enterprise management or general legal practitioners are familiar with. So usually the tax departments or the management personnel of the multinational companies, they just can't understand. They sort of feel quite confused when confronted with customs officers. One important reason is that the legal system enforced by China Customs is quite specialized and quite complex. So that contributes to the risks, the customs compliance risks that may arise in the cross-border transaction, because they can't understand the customs issues, the customs laws and regulations. They are not aware of these issues, as in the two cases we have studied. The enterprises management personnel, they sort of felt quite confused. In our talk with the enterprises management, the repeated they were quite confused. But after our explanation, they felt quite they sort of felt then understand why customs officers would inquire into their trade cross-border transaction. So this is from customs perspective. From company perspective, so the risks that may be faced by multinational companies include, but are not limited to, the following things. The first one is royalties and license fees and transfer pricing arrangements may be challenged by customs, and subsequently a large amount of duty may be pursued. So on this point, I would elaborate more on the on the background knowledge or information. This is related to customs valuation. What is customs valuation? Well, customs valuation determines the price base for the tariffs and taxes payable. Thus, transaction prices declared by enterprises are subject to strict customs examination and auditing. However, it is quite sophisticated in legislation and becomes even more complicated in practice. What elements or items of price shall be included in the transaction value requires careful consideration and legal assessment, especially in the case of transfer pricing within companies group. Customs valuation is involved with license fees and royalty, rental charges, commissions, brokerage, the process of subsequent resale, disposal, use of the imported goods, warranty arrangement, the expenses related with financing interest, technical training or assistance, and another customs terminology, assists. So assists means materials engineering development provided by the buyer free of charge or at reduced costs for use in the production or sale for export of the imported goods. So you can see there are a lot of elements that we have to take into consideration when we price the import goods that are related to customs compliance. The second point is that the customs valuation is also closely connected with the trade mode and the business arrangement. Usually, the same price item that shall be added to the transaction price in one trade mode may not be dutiable if the business arrangement varies. So that gives us a lot of flexibility and also a lot of uncertainty in customs compliance. That explains why royalties and license fees and transfer pricing arrangements may be challenged by customs. Let's move on to the other risks. If it is found that the import goods are declared untruthfully, then the importer may be imposed on administrative penalties or even criminal investigation, which then in turn may suspend the manufacturing or distributing operation. It's not just in theory, the risk. It actually happened with our clients in their actual operations. So that's why we put it here in our slide to remind our participants and your companies of the potential risk here. And also in our previous cases, our clients may come across the disruption to their supply chains because of the greater inspections at the border or even possible seizure of goods. When the customs they initiated criminal investigation, or we started some customs procedures. The last but not least is that non-compliances or irregularities may lead to the downgrading of the company's credit status. Because China Customs, has adopted the credit management of the importers and exporters. They sort of rate the importers their compliance level in terms of the rate the enterprises in terms of their customs compliance level. So if any uncompliance or irregularity happens, they will downgrade downgrade its rating. And then it may lead to greater inspections or various other troubles to the importers and exporters. And even it may have serious implications for the management personnel of an enterprise. Like, for example, if this enterprise is still liable to customs in terms of the tax or the tariff, then their management personnel may be faced with the travel restriction, which is imposed by the public security department. Because nowadays, with the state initiative of the social credit building initiative, the various government agencies and departments, they join together to punish, to sanction those individuals or the companies with poor credit level, with non-compliances or irregularities. So if the company has customs problems, that may lead to the punishment from another government agency or department. So the risks on not only stay with the daily operations, may also lie in their mergers and acquisitions in relation with China. As a target company may have compliance problems or other customs liabilities that are yet to be exposed and will be attached to the buyer. For example, the target company has manufacturing plants in customs controlled zones and irregularities in their operations haven't been discovered by customs. Or capital equipments imported by the target company under tax incentives are still within customs supervision period and may be liable for tariff and taxes. So these undiscovered or uncovered liabilities or irregularities could be the potential problems for the companies that acquired merged with the previous company. And moreover, risks may also exist in relation with third-party service providers. As we already mentioned in the case study, the third-party service providers, such as customs brokers, logistics service providers, they are always involved in the supply chain operation. The third-party service provider usually regard fast customs clearance as their first priority, attach low importance to customs clearance. So this could also pose potential risks for enterprises. Recent developments. As we have been following the customs development in China, we can see obviously the aggressive, comprehensive approach being adopted by China customs officers in enforcing compliance. Second one is transfer pricing is drawing increasing attention from China customs. This year, it's already listed by Customs Audit Department as its first priority in its work in the following years. So we expect that there will be a lot of the audit cases relating to TP in the following years. Third one is China Customs is shifting its focus from supervision of consignments of goods to regulation of the enterprises. China Customs actually has carried out a lot of unprecedented reforms in recent years, along with large-scale legislative amendments. These reform efforts will, on one hand, greatly expedite customs clearance, on the other hand, reinforces enterprises management and regulation prior to and post customs clearance. So in most cases now, enterprises will go through customs declaration process free of customs verifications, and duties will be calculated and paid based on their self-assessment. So in doing so, the onus for ensuring declarations to be accurate has totally moved to the importers, because the customs will not verify whether you declared right or not, and they will supervise the import-export activity post customs clearance. So once they find the declaration is not right or is not lawful, then they will pursue corresponding responsibilities. Another point that may be also worth our attention is that China Customs has established information exchange mechanisms with the State Administration of Foreign Exchange, and the enterprises' foreign currency payments are under close watch by China Customs. So we often got the question from our clients that how China Customs got to know the paid royalties and license fees to their parent company. So this explains why China Customs did it. So it also means that we have to pay attention to this. If you have these payments not under the item of goods transaction, you should be aware that the customs also supervises this flow of the foreign exchange across the border, and then they will follow this clue to inquire into the trading facts to see if the enterprise comply with the customs laws. Okay, the final part is about the practical action suggestions. The first point is, I'm sure that the participants and companies, after the introduction so far, maybe may get some feeling and knowledge about China Customs and the relevant risks. So the first point is that you have to pay high attention to customs compliance issues. I think that the biggest risk is that they underestimate or not aware of China Customs compliance risks in their management of trade and supply chain. So from now on, I suggest multinationals in their cross-border transaction should pay high attention to customs compliance issues. Otherwise, major serious consequences may follow. The second point is that groups company should adjust and upgrade their mindsets, shifting their risk management focus from each consignment or impulse to enterprise as a whole. As the China Customs is shifting its working focus, the enterprises, the importers and exporters, shall follow this trend to shift their risk management focus. The customs officers and auditing officers, they usually look at the enterprise as a whole. They will examine your financial books, accounting records to supervise your importing and exporting activities rather than the consignment of rather than the import goods consignment by consignment. So if we in our management shift the focus this way, that means we can have a more effective cooperation and communication with customers. So the third one and the fourth one is about the TP and the intercompany agreements. So intercompany agreements, especially in relation with distribution, licensing, research and development, marketing services, always play an important role in customs audits of TP. And other customs issues or processes. They form a key part of basic documentation requested by customs, and are usually under close scrutiny of customs officers. Customs officers examine agreements generally to identify the trade, the financial and license arrangements, and specifically to discover clues as to customs valuation and other issues, to search proof in favor of customs claim. Besides, any inconsistency or conflict of the agreements with other documentation may be used to challenge enterprise's claim or defense. In practice, you will see a lot of customs decisions quote clauses or words from the intercompany agreements as evidences to support the conclusion. In our experience, it isn't rare that some agreements, being unaware of customs issues, voluntarily revealed their problems to customs. So the intercompany agreements is of great importance in relation with customs audits and examination, though there's no specific requirement yet. To further give you some examples in our suggestion for these 2 points, like in the royalty and license agreement, it's suggested that usually we see a lot of royalty license package, different rights they packed together into one package, and then they price it with one particular number, and that this practice would lead to some serious outcome when challenged by China Customs, because they may include the whole price into the customs value, unless you can provide strong evidence allocate or apportioning the royalty and license fees. So we suggest that when we formulate the license agreement, apportion the license fees corresponding with relevant rights, rather than putting patent rights and the trademark rights together. So this is one example. And another example it's also happened in our practice. They have sales contract and service agreement or license agreement. And usually they associate in the clauses of these agreements, they associate these agreements with each other. That gives evidence to the customers that your import goods, license fees, royalties, or other service fees or other payments are related with the sales of the import goods. So it's just there should be no such clues or such clauses or provisions in these agreements that connect themselves with other agreements. So these are some examples I would like to give in these 2 points. And last point is that it's better that to do self-check of your existing practices and examine the current trade modes for risk prevention purposes. When the risks materialize, then it would mean a lot of serious consequences. So it's better that to do some self-check before the risks materialize. So I guess that's all I want to share with you in my presentation. Thank you for your listening, and thank you, Paul. Paul, are you there?
Yes, hi, it's Paul Sutton here from LCN. Thank you very much, Harvey, for sparing the time to share your experience with us. I think one thing that is really clear is that China authorities, including China customs, are taking a holistic approach to their enforcement, and it really reinforces the message that I think we've given all along to multinationals, is that they need to take a holistic and multifunctional approach to designing their agreements and their compliance strategies. So thank you very much to everyone who attended this webinar. If you do have any questions for Harvey or for me, please feel free to contact us by email afterwards. We will circulate the slides separately. And finally, thank you again to Harvey.
Thank you. You're welcome. My pleasure.